and welcome to Season 4, Episode 3 of ARBinBRIEF, a practical video guide on handpicked arbitration issues. My name is Deniz Ozyildiz Gedik. I'm part of the ARBinBRIEF team and I practice international arbitration with Akıncı Law Office in Istanbul. I will be moderating today's episode on Front Loaded Arbitration Procedures, featuring Alexandra C, who is a partner at Pestalozzi Attorneys at Law in Geneva, and Naomi Briercliffe, who is a partner at 𝗔𝗥𝗕𝗙𝗥𝗕𝗙𝗥 in London. While the practice of front-loaded procedures may vary among arbitrators, we have the opportunity to explore the approaches of our esteemed speakers who brings perspective from both civil law and common law traditions. Let's start with defining what we mean by front-loaded arbitration procedures. Alexandra, could you please explain the key differences between front-loaded procedures and a standard arbitration procedure?
Thank you very much, Deniz, for having me on this new episode of ARBinBRIEF. It's a real pleasure to be here and have this conversation with you and Naomi on front-loaded arbitration. So indeed, what is front-loaded arbitration? Well, what we meant is a procedural approach that requires the main steps of the arbitration, so to speak, the heavy-loaded steps of an arbitration, to take place at the beginning of the proceedings instead of having them spread out throughout the process. As you know, in ordinary arbitration proceedings, and by that I mean non-expedited proceedings, there are usually 2 rounds of written submissions before the hearing. That is a statement of claim, a statement of defense, a reply, and a rejoinder. So typically in a front-loaded arbitration, the claimant will be required to present its entire case, including all facts, all legal arguments in its statement of claim, and then submit all the supporting evidence, be it documents, witness statements, expert reports, at the same time together with its statement of claim. And similarly, the respondent will be expected to set out its case in full already in its statement of defense. And then with the second round of written submissions, that is in the reply and in the rejoinder, the parties will be expected to address only those new facts and new arguments that are raised in the other side's submission. So in short, the parties are required to lay out their entire case at the outset of the arbitration and will not be entitled to withhold any argument or evidence for a later stage, be it that they would want to take more time to refine their case or for tactical reasons. And by contrast, in standard arbitration procedures, as you've called them, we typically see a more gradual buildup in the presentation of the case. So in that model, the parties' initial submission can only consist in a short outline of their position and then be followed by subsequent submissions where evidence and arguments will be introduced incrementally. And so in that respect, this could be more similar to what we see in some domestic procedures in some jurisdictions, like in common law ones in particular. That said, in my experience, this so-called standard approach is actually not the norm in modern arbitration. And I would even venture to say that it's rather the front-loading approach, which has become the standard approach and which corresponds to the current best practices in international arbitration. It's reflected in a number of arbitration rules, the UNCITRAL arbitration rules, the Swiss rules of international arbitration, the recently revised ICSID arbitration rules, to cite only a few. And so why, you will ask me perhaps, why is it so popular to have a front-loading arbitration? And I think it's mainly for efficiency reasons. Front-loading allows to identify and, if necessary, to clarify the key issues really early on in the process, which results then in a more streamlined and a faster resolution of the disputes. And the other main driver is really also to minimize the risk of surprises and to discourage the parties to resort to dilatory tactics by raising new arguments, facts, or evidence at the 11th hour. There are also downsides, that being said, to front-loading, in particular for the respondents who may feel pressure to really set out their case in full in their statement of defense when deadlines are already tight and when they still developing their understanding of the case. Front loading may also increase cost and may also give rise to satellite disputes as to what is really responsive in a reply submission. So that's why, in my experience, front loading is rarely applied in a strict way, and a certain flexibility is necessary on the part of the arbitral tribunal. And lastly and importantly, but I will stop there, let's recall that whatever the approach, front loading or standard, so to speak, what is important is that the rules of the games be discussed and agreed with the parties at the outset of the arbitration.
Thank you so much for this great definition. And my next question is to Naomi. In your experience, under what circumstances do arbitrators typically choose to apply specifically front-loaded procedures?
So thanks very much, Deniz, and I echo Alexandra's thanks for having us on this edition of ARBinBRIEF. I'd just like to first say that I completely agree with Alexandra that front-loaded arbitration is really standard practice. In my experience, the standard is that parties are expected to provide their full case, including their factual and expert evidence, in their first submission, whether that's called a memorial or a statement of claim. There are certain industries, such as the insurance industry, in which arbitration is used and a common law litigation style approach is adopted to the arbitration. And by that, we're referring to the procedure where parties first provide a statement of case setting out their claims and a summary of the facts in high level before document production, and a later evidentiary phase where witness and expert evidence is exchanged. But the use of that style, as Alexandra mentioned, is less common in general international commercial arbitration cases, although on occasion there might be justification for it. And again, I also agree with Alexandra that the reason for the front-loaded approach in most international arbitrations is efficiency. Due process requires that each party is given a reasonable opportunity to present their case. If the parties are able to produce new claims and evidence at any time within the proceedings in order to give the other side a fair right to respond, the proceedings could just drift on forever. To supplement the expectation that arbitration needs to be front-loaded, what we're increasingly seeing is that arbitrators include in their procedural orders statements confirming the rules of the game in this regard. So provisions setting out that it's mandatory for parties to present all of their claims and evidence up front, and that replies should only be responsive. And as Alexandra mentioned, we also see this reflected in some rules. And I think that the ICSID rules go the furthest at the moment in this regard. So the 2022 ICSID rules set out clearly that the reply and rejoinder should be limited to responding to the previous written submissions or addressing new facts that could not have been known at the time of the first round of pleadings.
Thank you so much for your answer. And as a follow-up, how would you prefer to effectively incorporate front-loaded procedures in the proceedings when you sit as an arbitrator?
So as I explained, so in my experience, it's sort of a standard practice that arbitrations will be front-loaded. There's only limited cases in which it's not appropriate to apply that procedure. Nevertheless, unless the relevant rules set out clearly that the expectation is that reply submission should be responsive only, it can, in my view, sometimes be helpful for the first procedural order to contain that expectation. So as Alexandra mentioned, it's always important to have the rules of the game set out up front. And therefore, in applying a front-loaded procedures in the cases where I'm arbitrator, I have a tendency to propose that that is contained in the first procedural order. Nevertheless, I agree that there needs to be some flexibility retained. And so the expectation, if it's contained in the procedural order, needs to be very carefully worded to maintain that flexibility. Also, it's very important to be careful about how the expectation is worded so that you don't end up with lots of procedural battles between the parties about what constitutes new evidence or new claims, because that itself can be procedurally inefficient.
Thank you so much. That was very helpful. And Alexandra, would you like to share your thoughts as well?
Yes, thank you. Perhaps briefly, what I sometimes find helpful is to provide for a cutoff date expressly at the outset of the proceeding and set out a rule that after a certain date, no new evidence or no new factual allegation can be submitted in the proceedings. And typically, this cutoff date will be set out sometime after the last pre-hearing submission and before the hearing. Now, some may say that providing for a cutoff date will, precisely entice parties to submit new evidence or allegation by that point. But that has not been my experience. First, because I made clear to the parties at the CMC that at the case management conference that the tribunal will not entertain, additional written submissions or witness statements to be filed by the cutoff date. And secondly, because I think the parties realize it's also in their interest to submit their allegations and evidence with the written submissions to make it more coherent. Still, it can happen that parties will seek to rely on the cutoff date to file some additional documents. This can be justified and even maybe helpful to the tribunal. And if it's not, then the tribunal will, in any event, retain the power to decide on the admissibility of the evidence. And needless to say that in case new evidence is admitted by that point, then the tribunal will, of course, need to ensure that the other side will have an opportunity to address it, even if orally at the hearing.
Thank you so much for your answer as well. I think we're now moving on to our next subject, because you also mentioned how flexible it should be. And it is also important to know how front-loaded arbitration procedures interacts with the parties' rights. Alexandra, do you think it can potentially limit or affect the parties' rights in any way?
Thank you, Deniz. Yes, that's an important issue indeed. So we've talked about how front-loading can increase efficiency, but of course, it's also important to balance due process. And so my short answer to your question is yes, an overly rigid front-loading approach could impede a party's rights to be heard. So when there's an agreement with the parties to use a front-loading approach, but that nonetheless a party raises new facts or allegation or submits new evidence at the reply stage or even during the hearing, then what is an arbitrator to do? And well, as always, the answer depends on the circumstances of the case. But in my view, I find three elements to be helpful in considering that. First is to ask whether this new fact or new evidence is relevant to the dispute, to the issue in dispute. If it's not, then there's an easy solution. Secondly, why was such new allegation or new evidence not raised or produced earlier? And thirdly, what is the prejudice to the other party if the new evidence or new allegation is admitted, and conversely to the requesting party if it's not admitted? So in those situations, arbitrators, again, it was said before, but they have to retain a certain flexibility to avoid prejudicing a party's case. But at the same time, they also should not give in to a due process paranoia out of fear that their award will be challenged if they don't accept any new single piece of evidence. And in that respect, the arbitration, the seat of the arbitration and the legal framework will be quite important for an arbitral tribunal to feel comfortable to reject belated evidence. And for example, in Switzerland, the Swiss Federal Supreme Court has generally shown support for front-loaded arbitration, as long as, of course, as each party has a reasonable opportunity to present its case. But a reasonable opportunity does not mean, a limitless opportunity. So the Federal Supreme Court has made clear that evidence, for example, should be submitted in due time and in due form. And the right to be heard does not include an absolute right, for example, to a second exchange of written submissions. So this should give comfort to arbitrators that they can implement front-loaded proceedings and resist belated attempts from parties to submit additional allegation or belated evidence when it's really not justified.
Thank you so much for giving the Supreme Court's perspective on it as well. I understand that it encourages the arbitrators, it gives them some strength to enforce the procedures if needed. And since we are already talking about it, I will also ask Naomi's opinion on it as well. When we say flexible, do you think there are any exceptions or scenarios where arbitrators might deviate from front-loaded procedures? And if so, what are they?
Thanks very much, Deniz. So, I mean, as I explained before, there are certain industries in which common law style court proceedings are typically followed in arbitration, and those are not front-loaded. And such procedures may also be followed in some domestic cases in common law jurisdictions, because the procedure is what the parties know and understand and expect. And so that can actually be more efficient. Another example of when it might not be suitable to expect the parties to file all their evidence up front is when one party alleges that the other party holds all of the evidence relating to the case. And so it's not possible for them to file any of their evidence at the outset, or at least it will be very difficult. I think in those cases, it might be appropriate to have an exchange of evidence after the document production phase. Nevertheless, even in those cases, it's appropriate to indicate that after the evidence phase is closed, there should be no further evidence submitted unless particular circumstances arise which make that necessary from a due process perspective. And more broadly, in any international arbitration case, what I think we mean by flexibility is the flexibility to ensure that due process is accorded to both parties.
Thank you so much for your answer. We are out of time for this recorded session, so I would like to thank both of you for this very insightful session. And we would also like to thank our partner organizations, 𝗔𝗕𝗙𝗏 and AAA ICDR Asia Case Management Center for their invaluable support in making Season 4 possible. We are also truly grateful to the many organizations that support the marketing of our series around the world. And for those of you who are watching us over YouTube, our video ends here. Thank you for joining us. To see future ARBinBRIEF videos, please follow us on LinkedIn and like and subscribe to our channel on YouTube. We would love to hear your comments and feedbacks, and you can register for our next episode on www.arbinbrief.com. We look forward to seeing you there.